Good morning, everybody, and welcome to the Mason Hayes and Curran Construction Contracts and Insolvency, What are the Implications seminar. Today we're going to take a pretty high-level look at construction projects in development that get into financial difficulties. We're going to look at it from a number of perspectives, from a lender's perspective, from the employer developer perspective, and the contractor's perspective. On our panel this morning, we have Frank Flanagan, who's a partner in dispute resolution. He's an expert in the areas of insolvency and restructuring, examinerships, schemes of arrangement, and other bespoke rescue scenarios. We have Shane Dolan, a partner in our construction, infrastructure and utilities group, with lots of relevant experience in dealing with construction contracts and projects. We also have Cathy, Senior Associate in the Financial Services Department, who's worked in London as well as Dublin on lots of sophisticated secured lending and development finance transactions. And my name is Micheál, and I'm a partner also in the financial services team. So this morning we're assuming debt-financed construction development project with a reasonably sophisticated loan and security document package, broadly based on the Loan Market Association suite of documents, which would be modified obviously for an Irish project. But the principles we discussed would also be applicable for projects that are financed, not necessarily strictly on those terms either. With that in mind, we'll look at the early warning signs, things to look out for, where a project might be slipping into difficulty or one of the parties might be heading towards a insolvency situation. We're going to look at the finance and the security package, focusing on construction specific issues as well as some insolvency points. And then we're going to look at the typical insolvency processes in the context of construction and some issues in construction contracts to be particularly aware of. So there'll be a Q&A as well. So if you want to submit your questions, we can pick those up at the end. If we run out of time, we'll be able to address those individually by email afterwards. And there will also be a poll. So we're going to stick the poll up now and give you some time to answer this question. So the question is, will there be significant uptick in developer insolvencies and when will it happen? So stare into your crystal balls and you have a choice. No big uptick. Before the end of 2020, we'll see such insolvencies. Q1 2021 or Q2 2021 or sometime later. The various measures and whatnot that are in place will keep things going until later. So I'm aware you're looking at a slide as well. You will get to see our faces later on. So, okay then, thanks for participation in the poll. So almost neck and neck that it will be next year or either Q1 or Q2, but a big majority thinking that we'll probably get to Christmas without much activity, and then after that things will start. Okay then, thanks for that. So we're going to talk to Shane first. So Shane, we need to, we're going to look and ask you about what are the early warning signs to look out for in terms of contract scenarios. So we're going to look at the contract package now. Next slide. There you go. So that's the kind of contract package. So
yeah, Micheál, do you want me to? So yeah, so in terms of early warning signs, the most obvious one is where a party in the chain of construction contracts isn't being paid on time. And obviously as lawyers, that'll typically manifest in a contractor or a subcontractor coming into us and saying that they're not being paid and what are their formal options under their contract. So typically we'll give them advice around, do they have an entitlement to adjudicate, and if so, what are what the processes involved are. Is it an arbitration clause? Some cases where there's a sensitivity around adopting that kind of approach, perhaps a suspension of the works. And obviously outside of the contract terms themselves, there's obviously statutory procedures available So in the sense of if a debt was due and payable. So in the construction context, that might be an architect's certificate that remains unpaid. Then it may be appropriate to issue a statutory demand notice under Section 570 of the Companies Act. And Frank is going to touch on that a little bit later. In other ways, it can manifest in terms of a subcontractor seeking direct payment from the employer. So typically that'll be a nominated subcontractor seeking direct payment because the main contractor isn't paying him on time. Subcontractors and contractors might enter into invoice discounting arrangements with third parties to free up cash flow. And then I suppose probably towards the latter end, when insolvency is perhaps imminent, you typically see retention of title entitlements being enforced. To take an example, on Easter weekend, bank holiday, some years back, we received notice on Holy Thursday that a subcontractor had entered into one of my client's sites, and throughout the night, Holy Thursday and into Good Friday, continued to remove materials from that site. Guards waved their hands and said it was a civil matter. So obviously forced to get into the High Court on Good Friday and get an injunction to stop that. But that's the typical type of scenario employers face, and obviously contractors on the other side. But in that case, the contractor who wasn't paying his subcontractor, he went into liquidation 2-3 days after. So that's a good example of some of the instances you'll see when problems are arising.
Okay, thanks, Shane. Okay, Cathy, so we've identified the kind of early warning signs, risk factors in terms of a project that might be in difficulty. And as I said at the top, we've a reasonably sophisticated loan and security package in place. Could you take us through the principal kind of security and what are the main features of the loan agreement that will get examined by funder and that the employer borrower will really need to be aware of when there's potential for difficulty?
Yeah, of course. So I think, Micheál, if someone has come to us with the fact pattern that you've just described, be it a funder or an employer, the first thing that we'd really want to establish is what stage is the development actually at. The reason being, lenders tend to provide development loans in tranches rather than provide the entire amount up front. That allows the lender to control and monitor costs and progress. So if you were to tell me that the development was still in the construction phase, the first thing that we'd want to check is whether the lender still has the ability to stop further drawdowns because of the issue at hand. And that doesn't mean that, because there's any issue or potential issue, that a lender automatically has the right to prohibit any further drawdowns. It all will come down to whether the issue at hand constitutes a default under the finance documents. So you may absolutely have a situation where a potential default has arisen, or a potential issue rather has arisen, but so long as the borrower is still able to satisfy all of its CPs, the lender may still be contractually obliged to advance the loan. But in any event, it's something which both the funder and the borrower should be really careful around. Secondly, where there are hints of difficulty, rest assured that the lender will be conducting a really detailed analysis of the rep and warranty package that the borrower has provided under the finance documents. And again, looking really closely at the default provisions to ascertain whether in actual fact a default has occurred or looks like it might occur imminently. Thirdly, at this point, if you're a lender, you'll be taking a really close look at your security package to make sure that the security that you think you have in place is actually in place. And you'll be ensuring that all of your security perfection steps have actually been undertaken. So when I say that, we're talking about things like, has your security been registered with the company registration office within the appropriate statutory timeframes? Your security over the development and the land itself, has that security been registered with the property registration authority? In these transactions, you would expect that you would have security over the development contracts, in which case notices of assignment should have issued to those contractual counterparties. And also worth kind of just noting that if you have taken fixed charge over book debts, you may need to notify revenue by way of a Section 1001 filing. In the same vein, if you're a lender funder, you'll be looking really closely at what enforcement rights are available to you under security documents. You would hope, again, from a funder's perspective, that each security document would have the independent power to actually appoint a receiver, and that such receiver would be able to enter into possession of and take control and sell the development. So in a nutshell, whether you're an employer, whether you're a funder, and there is a potential issue, you'll be looking really closely at your finance documents to see what the impact of that particular issue is.
Okay, and in the security pack itself then, are there particular features that in the context of a construction insolvency scenario, construction project, that you'd be looking to?
Yeah, so from a funder's perspective, again, you'd obviously want to see a really comprehensive security package in place. In particular, during the construction phase, there's quite a lot of risk for lenders. So the security package on these deals are often set up to enable the lender to actually step in and take over the development if that's required. More specifically, you'd hope to find, in the first instance, security over shares in the borrower. That enables a funder to take control of the borrowing entity and sell the shares in a default scenario. That would be an alternative to selling the development or the land. Secondly, and what you'll find on a lot of finance transactions, just as a matter of course, is a debenture from the borrower. And the debenture, if it is correctly drafted, should create security over all of the assets of the borrower. The most important assets in this context would be obviously security over the development and the site, any plant and machinery on the development and site, security over any credit standing to any of the borrower's bank accounts. You'd hope that the debenture would also capture, as I mentioned just previously, any of the borrower's rights under the building contracts and the other kind of key construction documents, over any performance bonds, and again, an assignment over the borrower's rights to any insurance proceeds relating to the property or the development. Thirdly then, Micheál, and perhaps more bespoke to development finance transaction, would be the provision of collateral warranties in respect of the key contractors and any other professionals. The collateral warranties are so important from a lender's perspective. Those are the documents which create rights and obligations between the developers, the contractors rather, and the lender. That essentially provides the lender with direct recourse against the contractors. The collateral warranties also often provide the lender with step-in rights, so that if there is any appetite on the lender's side to actually step in and complete out of trouble development, that they have the ability to do that. If we were looking at the collateral warranties from a funder's point of view, we would hope to see that there were that there were no limitations on liability really, or any exclusions. Finally then, you often see guarantees in these security packages from third parties, often the sponsor or perhaps the shareholders in the borrower. They can take a number of different forms. Often they comprise a completion guarantee that basically covers the risk of the borrower not being able to complete the development in time. You might also commonly see guarantees from a third party whereby they guarantee any cost overruns, or alternatively, they might guarantee any shortfall in interest, fees, or other periodic payments owing to the funder.
Okay, thanks very much. Turning to you, Frank, you've seen insolvencies and you've completed lots of restructures over the years. What are the steps leading into the insolvency processes, and in particular those steps in the context of a construction project?
Okay, in It depends on the process to some extent. Leaving aside step-in rights, which Shane will deal with and aren't really an insolvency process, if the lender wants to appoint a receiver, basically normally a demand is required. Sometimes a demand is not required for an event of default to occur. An event of default is going to be something like a payment default, potentially even a financial covenant breach, a lack of information flow. If on bigger projects, there's quite often a cure period. So if there's a failure to provide information, there may be a letter required from the bank to require a cure within a period. It doesn't tend to happen on smaller projects. So typically you will see a demand, and unless there's a cure period for that, which there wouldn't normally, for a payment failure, which there normally wouldn't be, the receiver can be appointed literally 24 hours later. The test is the mechanics of payment test. In theory, the borrower has the money and can just go to another bank and draw out the money to pay it down. So a receiver's job when he's appointed is basically to satisfy the bank, so he can sell the secured asset and walk away. He can, under debenture, be appointed as a receiver and manager and operate the business and complete a development, in which case he has to actually pay the preference creditors, which are going to be mostly revenue and employees, and then walk away. He doesn't wind it up. He's not responsible for collecting in every penny. He's not responsible for paying the unsecured creditors at all. It'll end up typically in liquidation. The other alternatives, any creditor who's owed a significant amount of money can petition the High Court to appoint a liquidator. The normal condition precedent for that is that somebody serves a statutory demand for payment within 21 days. Normally that would be for a sum in excess of 10,000. During COVID-19, it's actually been raised to 50,000. So if you see a statutory demand requiring payment within 21 days, that is a sign that somebody can potentially petition to wind you up immediately after that period. It's not supposed to be used as a debt collection mechanism. It is frequently used as a debt collection mechanism because the effects are potentially so severe, and people will typically pay up very fast if they can scrape the money together. The other process is creditors' voluntary liquidation. Usually only occurs when the directors decide the position is hopeless, and basically they need to put the company into liquidation to avoid a risk of reckless or fraudulent trading. It's cheaper than official liquidation, but both of the liquidation mechanisms, the liquidator collects in all the assets, pays the pref creditors first, then pays what a dividend. Typically it's going to be a small dividend to all of the other creditors, and the security typically sits outside that. It gets more interesting with things like examinership. There's a number of parties can appoint an examiner. Typically it's going to be the company. There's been one recent one where a creditor petitioned. The examiner's goal is to formulate a scheme of arrangement that enables the survival of the company and all are part of its undertaking. And we'll talk a little bit later, I think, about what can happen to contracts in examinership. Usually in examinership, a small dividend is paid. Usually there's a new investment, and usually the shareholders change, and you can petition to appoint an examiner for up to 3 days after the appointment of a receiver. So if a business thinks it has a prospect of survival and it looks like the bank is heading to appoint, the lender is heading to appoint a receiver, they need ideally to start preparing to seek to appoint an examiner as soon as they get the sense that a receiver is on the way. The other two processes are basically varieties of schemes of arrangement. There's a very simple scheme of arrangement can be put in place if you can get the support of 75% in number and value of all of the creditors and the members. And that doesn't involve court involvement at all. It's the sort of thing that's probably ideal if somebody just needs a payment moratorium and the main lender is on board and the employees can be persuaded. There's a much more complicated scheme of arrangement that does involve the courts with lower voting thresholds. And for either of the schemes of arrangement, you're going to see either an ad or a circular to the creditors upfront. So that's basically the
Okay.
steps to.
Thanks.
Sorry, Micheál.
Thanks for that. So, Shane, just kind of being aware of, we've got a wide variety of attendees on the seminar this morning. So if you could take some of the considerations that funders, employers and contractors would have to take into account when there's an insolvency of one of the parties in the chain.
Yeah, so Micheál, I suppose just perhaps taking the funder's perspective, initially when the employer or borrower becomes insolvent. Obviously it depends on the funder's security, but there's obviously typically a number of commercial and more security related options available to it, but the primary options are obviously to enforce the security, appoint a receiver, and I suppose to travel the perhaps less traveled road, and that's obviously to step into the project agreements. In the normal course, as you'd expect, if an employer becomes insolvent, if you're a contractor or if you're a designer who's owed money and probably considering that they're not going to get paid, they'll want to mitigate their losses, and they'll look quite quickly, I expect, at the terms and their obligations in the collateral warranties that they've given to the funder. So obviously they'll be looking to terminate their various appointments and the works contracts, and obviously to do that, they typically need to give the funder a notice that they intend to do that, to pull the termination trigger. In the normal course, you see varying kind of periods, I suppose decision-making periods within which they can terminate. They're typically 30, 45, 60 days. Some cases I've seen 90 days. But obviously from the funder's perspective, the more complicated the project is, the longer a period the funder will want to see, because as I'm about to say, there's quite a bit of information and decisions to be made around all of that. So I suppose just in terms of what the funder actually has to consider, well, in weighing up the pros and cons, if it's looking at stepping in, it'll need a technical analysis to be done. It'll need to understand how much work has to be done on the site, how much that work is actually going to cost, and what the effect will be on the market value of the asset after that work is done. And obviously on the legal side, banks typically focus on the step-in process itself. So in previous circumstances, we've given banks a lot of advice around all of that. And one of the key focus points from the bank's perspective is going to be the extent to which they're stepping into any obligations and liabilities that the employer has entered into. And perhaps just to give a bit of context, in a typical traditional project structure where you simply have building contracts, design appointments, typically the employer's obligations under those agreements are to give access and to pay the people that they've employed. But where you've got more complex developments, so in perhaps as a retail, a large shopping centre, for example, you have agreements for lease that the employer has entered into, development agreements with third parties. And in those circumstances, I've seen funders, for obvious reasons, get quite sensitive and focus very, very carefully on the development-related obligations, because obviously funders aren't really in the business of giving warranties to third parties about the quality of the work that's been done. In terms of, I suppose, kind of some of the practical things in collateral warranties that funders typically will want to see, they'll want obviously not to have to pay twice for the same work. So in circumstances where they've paid the employer and the employer has become insolvent before they've passed that money to the contractor, typically funders will not want to have to pay twice effectively for the same work. And obviously contractors will have their own views around all of that. As I said before, the decision-making period can get, obviously from a funder perspective, needs to be lengthy in the case of a complex development, because as I said, there's a lot of information to get through before they can actually make a decision around all of that stuff. And obviously, if they can get a clear look around the corner as to what liabilities they're going to face if they do step in, that's quite important for a funder. So the provision of information from contractors and designers as part of that, to be provided during that stepping in period notice is quite important from a funder perspective. Turning then very quickly to the, I suppose, the employer scenario, and looking particularly at the scenario where the main contractor has become insolvent. So typically there's a sort of effectively a two-stage process. There's, in the first instance, matters to be considered around the formal termination, and then obviously replacement being the second phase. Dealing with termination initially, obviously an employer needs to keep their funder up to speed with their decisions. So obviously most loan documentation will have, you'd expect to have constraints around the borrower or the employer actually pulling the termination trigger without coming back to the bank to seek consent and approval. So employers need to be careful to comply with that obligation, and that becomes particularly important in examinership context, which we dealt with last year, where even the smallest delay in getting that consent can have a material impact on the employer's position. Obviously, as part of the termination process, it's really important for the employer to terminate strictly in accordance with the letter of the contract. And if the employer doesn't do that, the employer is exposing itself to a claim that it's acting in repudiatory breach of contract and exposes itself to a substantial claim for damages. We saw one case a couple of years back where an architect had issued a termination notice on the contractor, terminating the contract as opposed to the contractor's obligations in the first instance, which was incorrect. And then secondly, terminating before the contractor had actually gone into liquidation. They'd simply received a letter about a creditors meeting, a notice. So those are the types of things that employers need to be very, very careful about and get legal advice before they pull those triggers. In terms of replacement contracting, appointing replacement contractors, obviously the usual kind of process involved when you're appointing any contractor. You'll go out to tender, you'll obviously get advice around the terms of that contract. But it's really important for the employer to understand exactly what the replacement contractor is actually warranting. For example, is he warranting the previous guy's work or not? And if he is, what effect that's going to have on the cost. I've seen, like, obviously in circumstances where the previous guy has done 10% of the project work, it may be, the replacement guy may be able to warrant that work, but in circumstances where the replacement guy is being asked to warrant 90% of the project, it's very difficult for him to be able to assess the quality of that work and obviously price it. So there are some of the practical considerations. Obviously keep the surety up to speed before you start appointing replacements. Understand your obligations under the bond. Most bonds do have an obligation to liaise with the surety before appointing a replacement. Important to comply with those obligations. In practice, my experience at least, sureties don't necessarily engage in that process, but they do want to be told. One last point I've mentioned just in the employer context is around direct payments. So in the standard RII contract, there is an obligation to make a direct payment, or there's not an obligation, it's a discretionary entitlement on the employer's part to make a payment to a nominated subcontractor. And where the main contractor has become insolvent, paying outside the main contract and paying a direct payment can cause an employer real difficulties. And because of the discretionary nature of it, Irish courts, Northern Irish courts have all been consistent on it, that if you pay it, make a direct payment in circumstances where the obligation is a discretionary one, as opposed to a mandatory one, you're potentially contravening the pari passu principle, and ultimately liquidators of the main contractor may come calling. So employers need to be careful not to have to expose and put themselves in a position where they have to make a double payment. Then just lastly, I'll deal with just very briefly with the contractor position where the employer has become insolvent. So obviously, where the employer is insolvent, the contractor, as I said, will want to mitigate its loss. They'll be looking to terminate and serve notices of termination, intention to terminate to the funder. They'll be looking at obviously mitigating and settling accounts with subcontractors. obviously since the Construction Contracts Act in 2013, pay when paid clauses are now illegal. So the main contractor won't be able to rely on those types of clauses to escape liability to his subcontractors. Other, I suppose, relevant issues are retention of title. Obviously, the main contractor is going to be focusing on getting his materials and goods back from the site. And Frank's going to talk about that in a couple of moments in a bit more detail. But obviously, from the subcontractor's perspective, where they have no direct contract with the employer entity, they're obviously going to face significant problems actually getting onto the site because they have no contractual entitlement to. And we've seen that arise any number of times over the last number of years. And the final point I'll just very briefly finish up on is obviously the issue of retention that's held in retention accounts. Obviously that's being held on trust for the contractor. So that, that's money that falls outside the liquidation. I think Frank will talk a little bit more about that in a few moments.
Okay, thanks Shane. So Frank, I got a couple of issues that Shane mentioned there. Taking those, and are there other kind of insolvency issues that you'd be particularly concerned with, where either on the you have a project on the cusp of facing an insolvent party, or even when entering into contracts to be aware of them in the first place and at the outset?
Okay, there's a few technical insolvency law issues that are fairly relevant, are particularly relevant in a construction context. The first thing that everybody should be aware of is that owners' contracts, which are contracts that require anything other than the payment of money, can be repudiated by liquidators and examiners. So what typically happens is the contract is valued by an expert and converted to, on the basis of a net present value calculation, and converted to a debt. And you'll get hopefully a dividend paid on that debt, and that dividend can be quite small. So, for instance, in examinership, a contractor could walk away from a contract that it thought was not going to be not profitable, and a small dividend would be paid in the examinership on the contractor's liabilities on that contract. Receivers have a very similar power. They can decide whether and for how long they're going to give effect to contracts from prior to their appointment. So they can effectively decide at any time during the receivership to repudiate the contract, leaving the other party with an unsecured claim for damages unless they've got security. There was a controversial High Court decision in Curran and Maynooth Business Campus last year, which has now been overturned by a Court of Appeal decision. And that decision basically found that the the receiver was responsible to pay for, and effectively the funder was responsible to pay for the repair of a defective car park. That has now been overturned. We're back to the previous position, and it's entirely clear a receiver can walk away from contracts like that and obligations like that. The second thing to pick up on Shane's point is monies held in trust do fall outside of insolvency, and monies on trust occur quite frequently in construction contracts. However, care needs to be taken that the account in which those monies are held is actually set up with the contractor's bank having waived the right of set-off over that account. Typically, every time you open an account, the bank will have a right of set-off across all of the accounts that you have. So if you become insolvent and you've got money in one account and a debt in the other, the bank will set that off before anything happens. The banks will set up accounts waiving the right of set-off. It's done, for instance, on solicitors' client accounts. I had this for a state body in relation to construction stuff. So anybody who's relying on that trust just needs to actually ask the question and make sure that it has been set up that way. Another point that is just a really time-critical point is in examinership, the proposed scheme of arrangement is at some point put to a vote of classes of creditors. If there's a guarantee in place, because the guarantor is potentially going to have to pay the debt, the beneficiary of the guarantee, typically the lender, is going to have to transfer their voting rights to the person who provided the guarantee, And depending on the timing of the meetings, that may need to be done on really short notice, and it can come down to 24 hours. And if that is not transferred in time, you can entirely lose the benefit of the guarantee, which is very significant. Picking up on another one of Shane's points, in construction, retention of title is actually very difficult. The usual construction contracts provide that once materials are delivered to the site, they become the property of the employer. But most of the supplier contracts with the contractor or the subcontractors provide that they retain title for the goods until they're paid for in full. And the contractor, as a matter of law, the contractors and the subcontractors can't transfer title they don't have to goods. So the strange piece with construction is once goods become fixed to the land, they become part of the land and can't be reclaimed by the supplier. There is a recent case where even gravel that was laid out as the sub-base for a road was held to be fixed to the land and couldn't be reclaimed by the supplier. Had it been in a heap on the site, it could have been reclaimed by the supplier. So retention of title just needs to be looked at very carefully, and you may find situations where somebody wants to hold off on enforcing simply in the hope that some expensive piece of plant is affixed to the land. The final thing I want to talk about very briefly is the structure and control of management companies, and this typically applies in things like big industrial estates. Very often in the past, and I think lenders have probably woken up to it now, management companies outside of the MUD Act were set up for these estates. They were often formed as public companies with friends of the developer as members. They had, and potentially directors, there were contracts for sale of the common areas. And the whole contractual matrix wasn't looked at well enough to ensure that you could effectively take control of the management company when you came to an insolvency scenario. I mean, potentially you could look at an industrial estate that suddenly in an insolvency scenario might be more valuable as development land, and you need to vary the estate, you need to change the road layouts, and typically those were not set up for easy enforcement. So that's a whistle-stop tour, I think, of what I think are probably the issues I've had most entertainment in the past few years.
That's great. Thank you very much. I know we're quickly running out of time, so I'm just going to very briefly go to Cathy. Given the environment we're in, and certainly, you know, stresses and strains being affecting all businesses in this area, are there kind of two things, Cathy, in terms of the security or finance package, in terms of documents that we should be aware of, and the information flow in particular?
Yeah, thanks, Micheál. So just a couple of the ways can ensure that it's obtaining an adequate flow of information in respect of the development. First one, quite bespoke to these types of finance transactions, is that a lender will often require the provision of interim reports on a regular basis. Those reports are prepared by the project manager and should include updates on things such as the costs and expenses, comped against the budget, and progress against the construction milestones to date. As I said, often provided on a regular basis, and we'd often see that done monthly. Another thing that's quite key from a lender's perspective then would be that most development loan finance agreements would require that a lender is notified of any defaults or disputes under the development documents, or one party's intention to terminate or suspend performance under the development documents.
Okay, thanks very much for that. Okay, I'd like to thank everybody for attending. We have some questions that have come in, so I'm just going to deal with one very briefly. Question is, does a party have to acknowledge a notice of assignment for the assignment to be able to be relied upon? No, so in order to perfect an assignment, you do need to notify the counterparty. So you need to tell them that the contract in which they have an interest has been assigned by way of security in favor of a secured party, or funder, or lender, or bank, etc. And best evidence that you have notified that person is to have them acknowledge receipt of that notice. if they don't send you back a written acknowledgement, that isn't necessarily fatal to the fact that you have signed that contract and made the notice. If you can demonstrate that you have notified them, and also obviously it depends, of course, on the terms of the contract as to whether or not you're entitled to assign it by way of security. There was another question here about suppliers' retention of title claim to goods delivered. I know Frank spoke about that. To try and get to maybe some of the other questions, if further detail is needed, Frank, I'm sure I'd be happy to take an email on that.
Absolutely.
Finally, I think a question, Shane, for you. Funders and developers tend to get a lot of comfort from bonds being in place. What is our experience of them actually paying on claim?
Yeah, I suppose in a nutshell, it's mixed because I suppose I've dealt with kind of quite a few bond claims in the last few years, and a lot of them tend to end up in court, unfortunately. And it's probably not exactly what an employer had in mind when he paid out to get the bond. So they certainly don't intend to have to litigate through the High Court. But one case recently, actually, that ended up in the Supreme Court. So, people don't typically, when they pay for bonds, they don't want to have to pay hundreds of thousands of euros to actually get their money back. But yeah, it's mixed at best, Micheál.
Okay, there is another one or two questions, but I think at this point, conscious that we've kind of overrun our slot a little bit. Thanks again for participating. Please ensure you leave feedback. If you have any other questions, do get in touch. And depending on appetite, we may pick up one or two of these issues again in a future webinar. So thanks very much and stay safe.